Ryan Reynolds wrote a scene for the film. Is that true?
Yeah, look, I think that I'm pretty sure that everybody at some point wrote something for the film. And yeah, Ryan, Blake, and I was just so grateful that there's so many collective heads going in to try to make something so beautiful.
Do you remember which scene?
He wrote on a few scenes, I believe, and suggested a lot of things that made the movie better. I mean, the guy's a creative genius, and they work so well together.
Well, she told me Taylor Swift helped her get the role, like signed off on her audition.
I had brought in, I was casting, and I had actually brought in and showed her casting tape to Blake and Taylor, and they were both like, "Yes, her," and that's a true story.
It's Tuesday. We had a lot we had to cover yesterday. There's crime fraud exceptions, there's allegations of criminal misconduct, there's allegations of crimes that have been committed, there's allegations of civil tours, there's all these things that are going on right now, and then there are battles over discovery as it pertains to Belon versus Lively and Jones and Reynolds, and this entire big controversy that we've been reporting on for months. And we received a reply from Wayfair for the motions to compel financial documents, and then Kristen Taylor replied to the judge in her 3-page letter as to why they cannot permit Wayfair to obtain access to the security firm that downloaded information from Jen Abel's phone. All right, and we've learned that although they have publicly claimed many times they received all of these records and the evidence presented in this case from a court-approved legal subpoena in a lawful lawsuit, that is the point here. They haven't. Wayfair denies making those allegations. Blake Lively has not yet complied with discovery and given Wayfair a copy of the subpoena so that the subpoena may be inspected by Wayfair to determine what documents she requested of Stephanie Jones. And document discovery, we've learned, hasn't even started yet because they just finally signed a stipulated agreement regarding electronic storage for all of the discovery that comes in. That's both electronic and hard copy paper discovery. How it'll be stored, how they're going to categorize it, what codes they're going to use, how they can search for documents, which is a joint stipulation they all filed and all agreed on as an order for how they will disclose paperwork to each other. So they finally signed a stipulated ESI agreement, which is really dull, but that is how they arrange the discovery and protect the evidence for the case. And so, now that that's all been decided, maybe now they'll begin actually creating documents to each other, but at this point, no subpoena has been issued to Wayfair, despite repeated public claims by both Lively's lawyers and by Jones Works lawyers that this was a legal subpoena from a legal court-ordered case, which we now know is entitled Ban's Sham. Now, before we sort of jump into what we do know regarding the subpoena, somebody either affiliated with Stephanie Jones or Blake Lively leaked it to the media. They leaked it to Daily Mail and Deadline, and under the strict provisions that they weren't allowed to reveal information on where the subpoena originated and what it was searching for, Deadline revealed in an article a couple of weeks ago that it named Lively and Reynolds, and the various companies and entities of the couple and the concerns, and refers, relates, and applies in the subpoena concerning any and all electronic records, data, documents, and communications in your possession, custody, or control gathered from a cellular telephone with the requested information from December 1, 2022 and forward, and the material was submitted not long afterwards. It's funny how the subpoena was looking for info about the cellular phone, but then they don't specify whose cellular phone it was, again not knowingly leaving out Jen's name, because then Jen might perhaps have to be informed, but her lawyers filed a letter yesterday. They needed to take a leave about it, and they needed to do extra pages than they should have done, and they needed to debate over this fraud exception crime. So, there's been a lot of fuss recently with Wayfarer and third-party subpoenas attempting to acquire information from third parties who aren't necessarily a party to the suit but who have information. And there's been a series of motions to quash or protective orders, and this one's regarding Edgeworth Security and it. Kristen is responding to the crime fraud exception, and she asserts that she was ambushed by this, and they are stating an outrageous theory that they never posited before. In all fairness, they didn't find out about the subpoena until like a month ago, so they couldn't have possibly raised it until recently, but again, her point is they're asking for this exception, but they haven't presented any evidence whatsoever regarding the actual crime that was committed, and that they have a burden to present evidence proving probable cause that the crime fraud exception applies. Then she gives some various reasons why they have not succeeded in arguing this correctly. So they state that they do not even try to relate any of their arguments to any specific privileged document or documents. They don't even attempt to explain, for instance, how the group of documents in May 2024 concerning defamation against Jones' works, 3 months prior to Abel's termination, could have been meant to enable an undefined alleged scheme involving post-termination conduct and occurrences. The crime fraud exception, they argue, only exists where there is probable cause to think that the specific communication was aimed in some fashion to facilitate or to cover up criminal conduct. And then the other thing is that they argue that Wayfair parties have no proof of their outrageous claims against Jones' works. They provide no proof of their claims that Jennifer Abel was falsely imprisoned by Edgeworks security staff. They provide no proof of their false claims that Abel was coerced by Jones' works to return the phone Jones' works gave her for work. They provide no proof that Jones' works hacked into everything from her personal iCloud and email accounts. And they show no proof of any of the spurious criminal hacking claims they make against Jones' works. And the only records they reference for the allegations is Abel's own amended countercomplaint, which is just as unsubstantiated, unverified, and unsupported. A complaint, however, is not evidence. I mean, I suppose she has to argue on behalf of Jones, but the same would hold true of Jones's claims against Abel, you know what I mean? Like, these are civil claims at this point, and I don't know, there are aspects of these arguments over finding out what needs to be relinquished that just irks me, because at this point nothing is a fact, right? Nothing is a fact on both sides, honestly. Goes both ways. They indicated the counter-complaint that's unsupported, unverified, and unsubstantiated, and the allegations in the complaint cannot be enough to establish probable cause to believe that fraud was perpetrated. Otherwise, by virtue of mere allegations of fraud in a complaint, a party could utilize the crime fraud exception to completely swallow the attorney-client privilege. In fact, Jones' works has sought to dismiss Abel's amended counterclaims, since the assertions are not merely inaccurate but would fail to prove any theory of law that she has, and Wayfair introduces no proof of a crime or fraud or Jones' works' participation in either. So they're actually basing it so heavily on the premise that the crime that Wayfair is claiming occurred was that she was forced to surrender a phone, without her will, and that she was wrongfully imprisoned. I didn't particularly read that as what the crime was, or the fraud that was done. I think I felt like the fraud that they were attempting to illustrate was that they had performed the subpoena by way of the fake lawsuit. That's basically what I got, and she discusses this in passing. In point of fact, only 2 documents aside from their own earlier pleadings are offered by Wayfair parties as pretended support for their position. A complaint by a third party, not Edgeworth, in New York Supreme Court, and a notice of discontinuance of that suit. Well, at least she's admitting this occurred, is she not? Neither of these reports provide any evidentiary or factual basis for any of the wild allegations of the Wayfair party. They have nothing to do with Abel's August termination. They have nothing to do with Abel's surrendering her Jones Works-owned iPhone to the company upon that termination or purported access thereafter. Even the attempt of the Wayfair party to link these 2 reports to Jones' works is backed up by nothing better than frivolous speculation and yet another bald recitations of things earlier claimed by the Wayfair parties. I mean, she just implicitly acknowledged that that fake lawsuit had nothing to do with Jen Abel, which raises the question, why did Jones turn over the contents of Jen Abel's phone if that lawsuit had nothing to do with Jen Abel's phone or her firing? None of this comes anywhere near the showing required to justify invocation of crime fraud exception. Their attempt to link these 2 reports to Jones' works is based on nothing more than crazy speculation. Deadline published a story and so did the Daily Mail because they noticed this reported subpoena and it was only provided to them by someone that possessed the subpoena, correct? And both parties went on record and stated that the Van Zandt lawsuit was where the subpoena originated from. So it just doesn't make sense that they're attempting now to claim it's a wild guess that Jones' works is connected to this action. Well, I guess it is, because why would they be connected to an action that they're not involved in? In addition, even assuming the bombastic claim of a fake action on their part, I do not find this to be bombastic, Kristen. Such allegations, even assuming on their face, are not sufficient to raise any cognate theory of a crime or fraud by Jones Works and Edgeworth that would justify the exception. The precedent case that Wayfair parties, quote, supports this. Their words to the contrary. Their bare assertion that Jones Works conspired with Lively to issue a legal subpoena in a case that Lively did not intend to fully litigate comes far short of fraud impairing the administration of justice, sufficient to support the exception. So they're admitting, perhaps, that Jones Works conspired to issue a legal subpoena. That's not quite what they asserted. It's like she's dancing around the absence of defendants. There were no defendants. No one was listed as a defendant. No parties listed. No one was listed. Their failure to provide evidence isn't surprising since the facts they state are untrue. Oh, so I suppose they didn't receive that data from the sham lawsuit or sham subpoena. Oh, now she's revisiting the crimes that occurred with the phone. So Jones Works did not jail Abel. It fired her in a conference room. It did not intimidate her. It gave her papers that she read and signed. It did not intimidate her. It asked her to return the iPhone that was its, and she did. It did not hack into her iCloud account or email accounts or even get into those accounts or any information about her. It forensically pulled information out of the storage on an iPhone that it issued to its employee to use while she worked for them. If the Wayfair parties had evidence in support of any of their inflammatory claims, they would have brought it before this court. That they did not both affirms the lack of evidence and destroys their opposition. So she isn't claiming they didn't employ this lawsuit, the fake lawsuit, to get Stephanie issue all of this and turn over all of this to Lively. They're just kind of like attempting to deflect and say that there wasn't any evidence. They're making outlandish claims, it's speculation, and then actually attempt to play down the utilization of a frivolous lawsuit where no one's identified and it's seeking a cell phone. Now, in honesty, the cell phone and subpoena business was provided to the media.
The question is, did she know that the subpoena was coming from a Blake Lively shell company?
The Doe lawsuit is a common lawsuit.
Is it an end around while it's legal?
It's absolutely not an end around. It's a common practice that if somebody's defamed, somebody's smeared, if something happens and they don't know who did it, then they can file a lawsuit. BillyBushIsTerrible.com. You don't know who did it. You want to find the person who has that website out there. You can file a Doe lawsuit where there's a plaintiff against Doe's.
And they attested that timing of the opposition immediately following and just 2 hours after the motion, its creation of an argument not spoken since more than an entire month of conferrals and reference to now-abandoned statement, all show that their response was pre-baked, media-designed ambush, and not reasonable reply to resolving an issue of legal dispute. The strategy must not be indulged, and since the opposition is deficient even on the lowest standards of invoking the crime fraud exception, the court will have to reject it and grant Jones Works' motion for the protective order. I know Kristen had nothing to do with this bogus lawsuit, and now they have to defend it. And Blake and Stephanie received horrible legal counsel, and Manette is the one who made this happen. But for these lawyers to continue to perpetuate and gaslight and pretend this lawsuit was valid, and here she's trying to disavow that Jones Works has anything to do with it, but Ezra Hudson and Michael Gotottle spoke with Deadline and affirmed that there is nothing improper going on here, only diligent and careful investigation. The Lively parties responded based on credible information and utilized standard tools employed like a DOE lawsuit and civil subpoena that are all completely legal and lawful for seeking claims and discovering the identity of unfamiliar perpetrators of illegal actions. This litigation revealed the Wayfair parties' scripted scheme, in their words, in their own text messages, to bring down Blake Lively, a scheme which they carried out without disclosure, transparency, or notice to Ms. Lively or the public, rather doing things in a manner they believed would be impenetrable. We have absolutely nothing to hide. Ms. Lively purposely revealed the subpoena in her initial filing so she knew it would be ultimately disclosed to the Wayfair parties in discovery, and that is what will occur as her claims proceed in the correct litigation process. So her lawyer said this is where the information originated, where Jones is stating to the court, well, you can't connect us to that. I do understand the judge is not reading articles and is not reading interviews and public comments, but the fact that they're saying this to the media and then they're saying something very different to the judge, I don't like that. And they're complaining about Wayfair doing all these end-arounds to obtain information, but that's exactly what they did with the fake suit. Even with all these third-party subpoenas Wayfair has been sending out, they're sending it as part of this litigation, and if the parties step in and wish to quash the subpoena, they are able to do so. So it's not like stating that what Wayfair is doing here is an end-around, because they're clearly offering this party an option to quash, and it's up to the judge whether they'll quash it or not, or issue a protective order. They're entitled, Wayfair is, to subpoena third parties. That's the whole purpose of a third-party subpoena. Parties don't get subpoenaed, by the way, you guys, so they're subpoenaing Edgeworth for their interaction with Jones, which technically isn't privileged in any way, since Edgeworth and Jones communicating is not privileged at all. If they discussed only with Jones or Jones Works, those wouldn't be privileged, and they weren't even looking for privileged information. It was her lawyers that indicated everything was privileged, and they do not want Edgeworth to comply. I have no idea what the judge will do here. But as far as other third parties are concerned, last week we do know that Taylor Swift's was subpoenaed. Yes, and yesterday Taylor Swift's lawyer Douglas Baldridge, who represents the singer out of Washington, D.C. and is with Venable, filed a motion to quash in the federal court for the District of Columbia to quash a subpoena to a third party where Wayfair is looking for discussions between Taylor Swift's lawyers and Ryan and Blake's lawyers, and Taylor Swift's lawyers with Ryan and Blake, not clients, but their discussion, which are really not privileged. I just realized that through Not Really Golden on TikTok. So anyone that is not represented by an attorney that speaks with them, their discussion are not privileged. So if the lawyer Michael Gautadl, who represents Ryan and Blake, is communicating with Taylor Swift's lawyer, it would seem that Wayfair wishes to understand what exactly they're communicating about. What is it exactly that they are discussing? What do they hope to organize here? And it might very well be to look and see whether Taylor received incentives here. Was Taylor as invested in not just this lawsuit, as well as, are they sharing on this case? Did they share when they were dealing with the film? What type of discussions are they having regarding this lawsuit? And based on what they submitted to the court, they submitted what the subpoena comprises, and they issued it on April 29th. It states all communications between you and, including without limitation, Baldridge and the Lively parties, including without limitation, their counsel regarding the action. So they're seeking information on this action, this lawsuit. All documents related to communications between you, including without limitation, Baldridge and the Lively parties, including without limitation, their counsel regarding the action. All correspondence between Baldridge and Gautadl regarding Blake Lively from June 1st, 2024 to date. Baldridge must include Douglas Baldridge. Gautadl must mean Michael Gautadl. Action shall include the lawsuits, and Lively party shall include Blake and Ryan and their employees, representatives, agents, subsidiaries, affiliates, blah blah blah. So they're looking for information from them regarding this lawsuit and the allegations in this lawsuit. Regarding what was Blake saying to Taylor's lawyers? What was Michael Gautadl saying to Taylor's lawyers? Are they collaborating on this? Now, interestingly enough, Taylor's lawyers did say in this motion to quash that they have no position whatever on the case in question. So there is a footnote in their motion to quash, and they refer to this underlying suit, and they said all the facts regarding the underlying suits are drawn from public filings on the dockets of the lawsuits or other public sources. None have been verified as accurate by Venable, and Venable does not take a position regarding the public accusations. Venable mentions the allegations merely to demonstrate that the sought discovery from Venable is immaterial and unjustified, so they're not asserting that any of the allegations on either side are accurate. They're saying that they don't take any position, which means they're attempting to say, we're not pro-Lively here. Perhaps attempting to distance Taylor from it as well, because Douglas Baldridge, if he's speaking with Lively and Reynolds or Gautadl, is only speaking with them about Taylor Swift, period. And Taylor's name isn't mentioned anywhere in here, and therefore it is separate from the subpoena she received, because they do reference the fact that they were reached by them last week regarding if they would be willing to take service on one of their clients. On May 8, 2025, attorneys representing Wayfair mailed Douglas Baldridge a different third-party subpoena on one of their clients and requested Mr. Baldridge whether or not he was representing for service on the behalf of this client. Up to this point, Wayfair has not claimed that Venable possesses information underlying claims and defenses because of the representation of a client, and such a claim would be inappropriate. So they are attempting to distance themselves and state that Venable has nothing to do with the movie. They have nothing to do with these allegations. They are not implicated simply because they represent Taylor Swift, and it's a very similar stance that Taylor took publicly when her people indicated that Taylor had no part in it, which raises the question, was Taylor actually involved in the casting as Blake Lively has indicated and as Justin Baldoni indicated, or was that just a fabrication that Blake created and then Justin had to roll with it publicly because of what Blake said? I don't know. Was her music used under license in the film? Yes. Are there issues as to why one composer was brought in and another one was let go, and was it about Taylor Swift having someone fired because she demanded it? Yes. But she claims to have had nothing to do with the music, nothing to do with editing, nothing to do with casting, nothing to do with hiring. Then did Blake then make up to Wayfair that I had to terminate your composer due to Taylor won't work with them? Then was she trying to deflect to, well, Taylor won't do it, so it was a means for her to get her own composer on? I believe one of the reasons that they're subpoenaing Taylor is to determine what Blake really told Taylor and how much Taylor is actually involved, since Blake made Taylor look like she was so involved. But if she's lying regarding Taylor's implication, and she was doing all of this behind Taylor's back and presenting to Wayfair that it was Taylor who wanted people terminated, it was Taylor who had to have this other music inserted, it was Taylor who needed this editor brought on, it was Taylor, if she employed Taylor as a bargaining chip in order to gain her own pay and Taylor was not involved with that, then that can refute her credibility. So if she's going to lie about Taylor and Taylor's involvement, what else is she going to lie about? And listen, I don't know what Taylor's involvement is, but if Taylor has nothing to hide, the best thing that she can do is answer the subpoena, give what she's got that's relevant, and move on. And if there is a deposition requested, respond to the questions as honestly as you can and be done with it. But if you refuse to cooperate and you believe there's nothing pertinent, the reason she's being brought into this is not due to Justin, it's due to Blake. Now, I don't know if a motion to quash is going to be filed by Taylor yet. That hasn't occurred. She just received her subpoena, and I'm certain she's speaking with attorneys currently to determine what she's going to do. But in any case, Wayfair's utilizing their third-party subpoenas strategically to look into the extent of what these third parties did and know that allowed the extortion and the redacted and the hijacking of the film by Lively and Reynolds, and they're entitled to issue these subpoenas. There is a right of judges to quash. Wayfair did not respond to the D.C. case motion. They're going to need to hire a D.C. lawyer now. And they didn't even respond to Kristen because they can only respond to Kristen unless they file a leave to file, since the judge had already indicated no more responses unless there's a leave to file to the court. So right now they haven't responded to that subpoena, and they have yet to respond to what's happening in D.C. So we'll have to see how this all plays out. It seems like everyone's blaming them for doing this for a fishing trip, but it seems like they're trying to find out what Blake and Ryan were up to behind the scenes with, and what Stephanie was up to behind the scenes with the company that pulled the data, which they're saying they didn't access the iCloud, they didn't access the emails. There must be some proof from Jen Ale that she is aware that they retrieved something from either a Gmail account or from her iCloud that she is aware would have been taken only from the iCloud. And Kristen is not saying anything was retrieved from there, but Kristen was not included in that subpoena, so how would she know? She wasn't involved in the extraction process either, so how would she know? Is she acting on the word of Stephanie? Because that word is, we already know about that. And Laton's lawyers essentially requested the court about monetary damages and financial reports, and they faxed that late last night to the judge. So Kevin Fritz informed the judge that conflicting statements Vivacious simultaneously admits that the Wayfair parties have affirmed that they will provide non-privileged documents regarding their damages, and wrongly contends that the Wayfair parties have declined to create certain financial records pertinent to their damages, considering there is no requirement for judicial intervention. At this point, it would seem that Lively's real motive in filing the motion was not to force discovery, but to create a headline for the press whether or not the motion is wasteful of judicial resources, and for good measure it should be remembered that Lively herself has not yielded a single document or elaborated on how she searched and obtained the documents her counsel purportedly obtained from her but did not yield to us. So basically, like, why are you appearing in front of the judge when you haven't presented us with anything as well? Blake and the parties meet and confer Wayfair parties assured Lively they were gathering documents responsive to her requests and that they would provide non-privileged documents regarding their respective damages. Contrary to her ongoing mischaracterizations to the court, they did not decline to provide the requested documents bearing on that loss. Additionally, the Wayfair party indicated that if upon receiving the damage-relevant documents the Wayfair parties have committed to producing, Lively thought other documents should be produced, then she should advise them of such stance, and they may sit down and discuss in good faith the issue of that matter. They allege the Wayfair parties have already made commitments to provide documents relating to their damages, said documents which can include, for example, financial records indicating a drop of business revenues. However, the motion does not justify why the net worth of one of the parties to Wayfair is pertinent to any claim or defense of a party, and proportional to what this case is in need, and denying the defendants' application to disclose assets, because plaintiffs made no evidentiary showing that defendants' current financial situation or net worth have a relation to the defendant's application for relief. They also are kind of speech. They speak on the private aspect of tax returns, and therefore, rather than submitting tax returns, you seek creating less intrusive documents, since tax records contain a great deal of sensitive information. They contend each time Lively finds the concerned information from the tax returns she supposedly requires. We are certain that any such information shall be easy to obtain from a less intrusive source. None of the instances that she's referred to, the judge merits submitting above doc events of tax returns, but subsequently they flag this up. Lively too refers passing to her RFP for all documents related to your liquidation of assets in 2024 or 2025 for any purpose relating to the film or the actions, including but not limited to the selling of shares in any publicly traded company. Nowhere in her 3-page letter does Lively even try to explain, let alone adequately explain, how any such responsive documents are applicable to any party's claim or defense during the meet and confer. Lively did not leave any basis for requesting documents regarding the liquidation of assets by any of the Wayfair parties. Indeed, even in her self-serving and lengthy summary and memorialization of the meet and confer, she does not state why documents relating to any liquidation of assets is pertinent, and then they want her, the judge, to deny this on the grounds that she did not meet and confer on her requests for documents relating to liquidation of assets in contravention of Rule 4C of his individual practices. So we'll see what the judge decides on that. So there's a lot happening. You got Taylor Swift's lawyers getting involved. You've got Kristen. You've got Wayfair now responding regarding the financial documents, and they have a set stipulation for how they're going to warehouse the documents. So documents are going to begin getting produced soon, but currently they're arguing over what needs to be compelled and what doesn't, and what needs to be quashed and what doesn't. What do you think? Do you think Kristen's covering? Do you think she's lying? What do you think about Taylor's attorneys taking no stance? Basically saying Taylor takes no stance, which is somewhat shocking. And what do you guys think about Blake and Ryan? Let me know in the comments below. Don't forget to give this video a thumbs up. Don't forget to subscribe to my channel if you haven't subscribed yet, and hit the bell so you never miss a video. Thanks so much for watching. Bye, guys.